Okay, so a change of a matrimonial regime will be governed by Section 21 of the Matrimonial Property Act 88 of 1984. So you can read that section. There it says that if you want to change your marital regime after you've already been married, you have to have a sound reason why you want to change it. It can't be to defraud creditors or anything like that. You have to give notice to your creditors about your intended change, because you can imagine, I mean, they are interested parties. They may say that they may oppose it, and they may say that it's not beneficial to them. They think that you are trying to defraud them, and there has to be no prejudice to any other party for this proposed change. It's an ex parte application that is jointly applied for between the parties, and notice is given to the deeds office. It's served on the deeds office, and it also has to be published in the Government Gazette and also in the newspaper at least 2 weeks before the hearing date. And there has to be also an explanatory letter to the creditors advising of this change and why you want to do it. It's brought, as any application is, on notice of motion and founding affidavit. In that founding affidavit, now I just want to remind you guys that when we are dealing with applications, it's an applicant and a respondent. So you aren't talking about plaintiff and defendant, especially in this kind of situation, because there is no plaintiff and there is no defendant. They're just, applicants. So in your applications, the plaintiff and defendant, they are changed to applicant and respondent. Just be mindful when you are drafting of these changes, because I have seen in the past people referring to applicant and respondent in a particulars of claim, which is, in the action, and where it's actually supposed to be plaintiff and defendant, and in affidavits they talk about plaintiff and defendant instead of talking about an applicant and a respondent. So in this affidavit, you will obviously state who the parties are, when they were married, and also don't forget, when you are speaking about something, attach. So when they were married, you will attach the marriage certificate, whether there are children involved or born of the marriage, you will include that as well. Don't forget, there's always the jurisdiction, always the facts of the matter. Why are you approaching court for this? You have to give the reasons. And also, obviously, now you are wanting to change your marital regime. If it is for an antenuptial contract, including accrual from in community of property or whatever it is, then you must attach that proposed A and C that you want to change your regime to. So you must attach that as well, and just that you have given the credits that you're going to be giving creditors notice, or you have given them notice. So everything has to be in your founding affidavit, and then also your prayers. That would also have to be there. So and any other information would be in your affidavit. So that would be section 21. You also have to, the attorney will then have to do an affidavit just confirming that the various steps have been taken, and print a copy of the Government Gazette as well as the newspaper, and attach it to the clip to the affidavit to show that it actually was served and publicized. Okay, so the next thing we are going to discuss is I'm going to take you through consultations when a new client comes in. So the first step is when a client comes in, you get them to complete a client information sheet. You speak about your fees. That's very important, because they need to know what your hourly rate is, what you bill for, how you bill. They need to know how much you charge for letters and phone calls and all of that. That would be in your fee agreement. So I would say that discuss your fee structure with your client, and most definitely, even before they see you, get a deposit. And during consultation, if you see that this matter is going to be quite a long, complicated one, and you need to increase that deposit, always cover yourself. Then you would by then already have an idea of more or less what kind of deposit you should be asking for. You have to find out what kind of matter this is, whether there are any prospects of settlement before they even defend it, because a lot of parties, they actually discuss with their spouse. They say, look, I want to get divorced, and they come to an agreement, and then at this stage you already know, okay, well, my partner and I, we've spoken about it, and we're just going to go through one person. There will be a deed of settlement that will be done, so then you know, okay, it's not going to be opposed. It's going to be, I don't know, like 3,000 rand or something, but in other cases, it's very difficult to ascertain. You can't tell your client, look, it's going to be so much, because you don't know at this stage whether they're going to oppose. You can just give them a rough estimate. If they don't oppose, this is how much it will be. If they do oppose, this is how much it usually is. But there could be interlocutory applications, or one other thing that also goes along with divorce actions is protection orders, and people violating those orders, then they get locked up, the police fetches them, so then it turns criminal. So then you've already quoted for this divorce, which this is why I say it's very difficult, because you don't know what's going to happen in between. So yeah, I always tell people, let's wait and see. Are they going to oppose? What are they going to say in their plea? Then we know at least where we stand. Are they going to do a counterclaim? What is the position? And we also need to find out from them whether they have tried marriage counseling, and whether their relationship is capable of being restored at all. We also need to find out exactly why they want to get divorced, what the reasons are for the breakdown of the marriage, because at the end of the day, when you are leading your client in the witness box, if the magistrate or the judge is not satisfied that this marriage has broken down irretrievably, then they have the power to postpone the matter sine die, so that you can go and get counseling or think about this divorce. This is something that can happen. So yeah, you need to know what the reasons are, so you can tell them, look, I think you should go back, try counseling, and then come back and talk. And then you can just see, look, will there be can there be early settlement? Do you think he's going to, or she's going to, agree to this? We need to find out whether there's a pension fund. What does the plaintiff do? What does the defendant do? Where do they work? What are the salaries? How are they married? If they're married in community of property, if they married ANC, get a copy of the ANC, get a copy of the marriage certificate, all the birth certificates as well, and explain to the client that if there are children involved, then the family advocate automatically would also become involved. You would then have to complete a form if there are kids involved, just to say who the kids are residing with, the names of the children, the ages, where they go to school, and whether there is any interim standard agreement in place where are the kids currently residing, all of that, you know. Are they known to the social workers, and yeah, all of that stuff that will assist the family advocate in doing the investigation. And this is now in every single matter. And I can tell you that the family advocate, they have the best interests of the children at heart. That I know a lot of parents sometimes say, okay, well, I'm going to take them 1 week, and then the next week they'll be with my partner, and then back and forth, back and forth. Even if the parents agree to that, it doesn't necessarily mean that the family advocate will. And in that particular example, the family advocate will probably not agree to something like that at all, because it's very unstable. Let's say the kid is 5 years old, or you know, that means that every week, every second week, the child's moving every week, or every second week, or whatever the agreement is. The child will be moving from one home to another home for years, until the possession is changed, or until the child is, you know, attains majority, or is self-supporting, or whatever the case is. So, or whatever the arrangement is, let's put it that way. And so that is very, very destabilizing. So a family advocate will not agree to something like that, even if the parties have. So you need to explain to them that a family advocate will get involved, and they will look at the arrangements, and they will ensure that it's in the best interest of the minor children. And yeah, so you need to get all those documents that I've listed, and any other relevant documentation, pension funds, list of you know, the assets, are there movables, immovables, what is it that your client wants? Does your client want, if they're married in community, 50%? Do they want forfeiture? Because sometimes you can ask for forfeiture, however, it's very seldom that the court will actually grant that. You have to have very compelling reasons to ask for something like that. For instance, maybe the one party, the defendant, has financially burdened the joint estate, has never contributed towards the estate of the parties. He's nowhere to be found. They haven't been together for many, many years, you know. So there has to be really compelling reasons to ask for forfeiture. And you can only ask for forfeiture for for something that is yours. So I cannot ask for instance, you know, your spouse to forfeit his pension in favor of you, but you can ask in that instance for the pension to be your pension, for him to forfeit the benefits of your pension, and then yes, and then you have to have compelling reasons, and for a magistrate or a judge to grant that. Okay, so you need a copy of the IDs, marriage certificates, ANCs, birth certificates of the children, pension fund documents, investments. Just be in possession of everything possible. Ensure that you know what the other side's salary is, what your client's salary is, because you may be asking for maintenance for the children, if there are children, and also there's a potential for spousal maintenance. Let's say your client isn't working, whatever. So you need to know all that information. And remember what I've said previously, that we've just had load shedding now. Remember what I've said previously, that it is not a right for somebody, a spouse, to claim maintenance. This is a discretion of the court to grant maintenance if they feel that 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 the spouse needs it for rehabilitation purposes. And I will also talk about that. I'll also talk about that a little bit later. So you also need to talk about cost implications to your client. You need to tell your client, look, this is how much you foresee this to be if it's unopposed, if they don't oppose it, and what the process is. There will be a deed of settlement done. What the process is, if you have to have, you're going to have the summons drafted. They'll need to come back for a second consultation, approve the particulars of claim, send it off, get it issued, have the sheriff serve it, and then you need to give them some time to defend, to see if they're going to defend it. If they come back and they say they're happy with everything, you draft a deed of settlement, and then you can settle the matter down. If they're no children, if they are, then you can just send everything to the family advocate to endorse and approve. And so you can explain what would happen potentially, and then if they do defend it, they will obviously do a plea and potentially a counterclaim, and then you would be in a better position to advise your client or chat to your client and see, okay, how can we meet them halfway? So your client, you also need to tell them that they will be liable for your fees after everything, if same has not been, if it's not able to be recovered by the other party, so they would be liable for your fees. So let's talk about the Divorce Act and the grounds for divorce. In terms of Section 4.2, there are three reasons why a court would accept that a marriage has been broken down irretrievably and grant the divorce. The first one is that the defendant committed acts of adultery, that the parties haven't lived together for a continuous period of a year or more than 1 year. The plaintiff was declared, the defendant was declared as a habitual criminal and is undergoing a prison sentence. And then we have, like I said earlier, in terms of Section 4.3 of the Divorce Act, if a court is not satisfied with the reasons that parties given for the irretrievable breakdown and the reason why they want to get divorced, then they have the power to postpone the matter sine die and ensure that the parties go for counseling and then come back and then report. And then still, if the parties haven't reconciled and they can't reconcile and they have gone through counseling, then they will grant the divorce. In terms of Section 5, this is where a curated litem would need to be appointed to protect the interests of the defendant. This is when the defendant is mentally ill or is continuously unconscious. Okay, so just bear this in mind. So for instance, if somebody is in jail, they are not mentally ill, they are not unconscious, they would not need a curated litem appointed. So keep this in mind. I have seen this asked, especially about this curated litem being appointed. So this Section 5 it talks about in terms of mentally ill, a defendant that's mentally ill, he would need to have been put into an institution, a mental institution, for a period of approximately 2 years, and 2 psychiatrists would have to prepare a report to say that he will not or she will not be cured anytime soon. In terms of unconsciousness, the defendant would have to have been unconscious for about 6 months prior to the institution of the action, and then also 2 medical reports would also be needed, and one would have to be from a neurologist.